4:52 p.m.
I'm going to try to finish this. If you just give me a minute, I will close it out. Under your bona fide error affirmative defense, what mechanisms are in place to assure that your client has proper assignment of a debt?
Well, they give us the file. That's pretty good proof. They have OALD, original account level documentation. I don't think they just picked that up off the street. Again, your client, and there's nobody else coming after Mr. Ward saying, hey, don't pay security credit services on this student loan that's almost running out on the statute of limitations. Pay us. None of that occurred. So I think they had the paperwork, and if they didn't, he wouldn't have settled it. End of story.
Do you have any procedures set up in written form that show the maintenance of procedures that you deem protect you even if you do make an unintentional violation? What are your written procedures to protect against that?
For what violation?
It isn't
venue?
No, sir. Do you have procedures set up, documentation, error prevention procedures? Is there a form that you rely upon, or written procedures to show a court you could use the bona fide error defense because of these procedures are set up? Do you have that?
I have procedures, and I've given you so much proof that we thought your client lived in Ferndale.
So
sorry.
Let me rephrase the question. I am asking you, do you have documentation of your error prevention procedures so that errors aren't made?
I don't even know what error was made in this case.
Well, you said that you're entitled to the bona fide error rule.
Yes.
So I'm entitled to ask you, what written procedures for the fourth time do you have that can show me or the court you took steps to avoid errors, but they happened anyway?
I can show you, I don't know the procedures. I can show you the FDCPA, which says we're supposed to sue them in the right venue. I can show you all the evidence that we thought show that your client lived in Ferndale, and apparently that was an error. There is another, when you do Ferndale, there sometimes, I'm sure you know this because you're the expert, sometimes a Ferndale address means the defendant actually lives in Royal Oak Township, and that's in the 45th District Court. So yes, I did run your client's address when I sued him to make sure that he actually, at the time, upon my information and belief, lived in the city of Ferndale.
But do you have written procedures to prevent errors? Are there? You keep not answering the question.
I'll have to go into...
Yes or no?
I don't know. I'll have to look.
Wouldn't you know, 9 years in the business, when you say I'm entitled to a bona fide error rule because of the procedures I've set up? What's set up? What written procedures do you have set up?
I have, when we do venue, we check problem addresses to make sure that we are actually suing the defendant in the actual, because of people like you and your buddy, make sure that we actually sue them in the right court.
Do you have manuals or guidelines that outline those?
I can describe it. Here we go. So, and I look at the voter registration, I type in the address, just to make sure it comes up. I'm sure Genesee County is a big problem area for me. Just to make sure we're in the right venue. I do that when there's ever a dispute.
And the voter registration you looked at for Mr. Ward, what
Yes.
address did he have?
I don't know. I type in the address that we have on file to
You didn't
make
look.
sure what court we are supposed to be in. So I'm assuming that when I drafted this lawsuit and signed it, as I do with most issues, I went to the voter registration, typed in 1400 West 9 Mile Road, Apartment 8, Ferndale, Michigan, 48220, and it said yes, he doesn't reside in Royal Oak Township. He resides in the city of Ferndale, and that's where we filed the lawsuit.
You're saying you did do this with him? And
Yes.
you learned that and you typed in his address?
Yes, I didn't type in his name, I just typed in the address to make sure that we're in the proper venue. Because of people like you. And even though in the
Wait a minute.
past you have put in affidavits of your other clients that we sued them in the wrong venue, even though, come to find out, even South Lyon really can be Livingston County,
I
can
don't
it?
really care. That's not the.
Yeah, it's
What I'm
another,
hearing now is
another
that,
brick in the wall.
what I'm hearing is that you put the address in, but you didn't put in his name
No,
in the voter registration database.
I
You
did
just
not.
said that.
Yeah, I did.
You did put his name in.
No, I didn't.
Why aren't you putting his name in the voter registration as you said as part of your procedure?
Because there's one field in this site, if you ever go to it, and you just put in the address, and it tells you what city it's in.
Why would you not put his name in since you're already there anyway?
Why don't you go to the site and I can tell you why? But if you don't know what you're talking about, maybe don't ask me a question. But there's one field in this form, and it just has address. It doesn't have name.
So it's true you did not put his name in the voter meaning him, registration database. You didn't put his name in, is that correct?
I didn't because there's not a field for that. You're correct on that. No, it's not true.
You of all people should know. You checking it out?
Yeah, no, I'm
Okay.
up for you.
So you believe you have a written manual or with a set of procedures that tell you to go to the voter registration?
You can go by name, or you can go by address.
Oh,
Well, he's right about that.
Yeah, you can go 2 different ways.
Yeah, but why?
He said no name.
Oh,
the field I use is the address field. I don't type in the guy's name.
why wouldn't you? I mean, so that way you're
Well-
reasonably calculated to make proper service.
Gosh.
Why wouldn't you use that?
I never.
As you just admitted, you're in the voter registration database anyway, where you can just put his name in it to make sure you have the right place. Why wouldn't you, so that then you reasonably calculated the correct address?
That's a great idea. Maybe I'll start using that from now on.
But you didn't in this case.
No, I didn't, because I wanted to make sure we were suing in the right venue, and based on a Ferndale address, you got to make sure you're in the right venue.
Then why wouldn't you make sure you're suing him in the right venue while it's right there?
Because all the documentation for the, how many times I can say this, pointed to him being at Ferndale. If it was between Ferndale and West Bloomfield, we went with Ferndale. I guess it was wrong. But honestly, if I did it again, I'd pick Ferndale every single time, knowing what I saw at the time I filed this thing.
So part of your procedures is you go to the voter registration database, which is quite clearly enabling you to put a name and an address in,
Right?
and your
Don't-
procedures
No,
don't require you to put the name in to
I don't.
avoid suing a person in the wrong district. Is that you're on the phone again. Is that your testimony?
I'm going to it myself. My testimony is we just do address on that because we're checking to make sure the venue is proper. All the other documentation that you've gone over painstakingly, again, showed he lived in Ferndale.
Other than the stuff that came
Yeah.
back.
Yeah. Is there an address there?
Yeah, there's
Okay. Where? Where is it? Oh, zip code. Thanks for not, yeah.
That's right.
Yeah, that's what I use.
Why don't you just put the person?
I go right here. Search for your city township clerk. That's what I use. Thank you.
But how does that make him a resident of that district when you're saying that's part of your procedure?
It doesn't.
To avoid errors
It just says
that occurred?
Can you let me answer? It just says that the address that we have that we think is good is in the city of Ferndale, not in Royal Oak Township. The end.
Okay.
He also said you can Google your clients and find his address right away. I'd love for you to try that because it don't come up.
Did you try?
I've tried many times.
So
And-
you tried that many times, but while you're in the database that will show you where he lives, you didn't try many times. Not at all.
It doesn't show you where he lives, but thank you for telling me how to do my job. Are we done yet?
What is your understanding of 1692I?
I have no clue. I don't even know what
Well,
it
that's
means.
obvious.
Oh,
you-
is that the venue one? Yeah, I have an understanding of it. Thank you.
1692I, 15 U.S.C. 1692I.
Is that the venue provision of the FDCPA?
Yes.
Okay, thank you. I have a very clear understanding of this.
Excellent.
That provision was instituted back in the 70s, so I couldn't file all my lawsuits. I'm going to use Michigan, for example. I can't file all my lawsuits in Ontonagon, even though I know that no client lives up there. And I would have to make them drive 10 hours to get to that court. I don't do that. I don't file all my lawsuits in a court where I know I'm going to win.
You're not
all-
answering the question.
Yes, I am.
Just tell me what you know.
That's my understanding of the venue provision and why it was put in place. My opinion is it was not put in place so we can do rinky-dink federal lawsuits because your client was in Ferndale and then he moved back to his parents' house in Bloomfield. Oh, by the way, your client spent most of his days still in this jurisdiction because he works at Mabel Gray in Hazel Park. Hazel Park's in the 43rd District Court. Seems like, at the time, your client was spending a lot more time in this venue anyway.
So
But
you
my
know because
understanding...
he works-
Stop.
He lives where he works?
I'm not going to answer that. I'm going
I
to
know.
keep answering your question. My understanding is that venue provision was designed to stop that obviously shady behavior of either filing a lawsuit in a venue that you knew that this debtor defendant could not get to without extreme effort, and or, I'm going to file all my lawsuits in front of a judge that I have a pretty good understanding with is going to rule for me every single time. That's what that provision was designed to stop. Thank you. That's my understanding anyway.
Let me hand you what's your considered your response to my motion to set aside default. I'm going to name it 15. Yeah.
Yeah. By the way, he was not in court for this at all, so he has no idea what happened.
So
He sent his
page-
associate to
you
do
see,
it.
is that what you wrote and sent to the court in response to Mr. Ward's motion?
Yeah?
And you say in the first paragraph, introduction, good cause analysis. In his motion, defendant has admittedly demonstrated good cause as to why he did not respond to the complaint.
That's what I said. It's a two-part test, buddy.
It is if you're going under 2.603. Yes? But he went under 2.612.
What's that exactly?
Just show it's in the wrong place. You don't have to show good cause.
Oh.
I don't know why you're laughing.
Go ahead, ask your questions.
Well, that wasn't his only presentation of why he should have the motion set aside.
Okay. I don't have his motion. Can you give it to me so I can look at it?
I'll ask the questions because you
Thanks.
answered the motion. And
Oh.
you're saying he demonstrated good cause as to why he did not respond to the claim, meaning he showed you that he wasn't living there. Is that what you're saying?
That's what it showed.
Right. And that's all you need under 2.612. You don't need to have a analysis and a
No,
good cause and a meritorious defense.
that's not my understanding.
Well, yeah, that's becoming clear. Do
So-
you have something that says he had to show good cause and meritorious defense?
That's what the standard is.
So you admitted that he has a good reason for setting this aside.
No, I did not say that. I said he had a good reason as to why he didn't respond to the lawsuit.
Okay, fair enough.
Yeah.
And the judge agreed with his motion and set it aside. Is that correct?
Yes, I will explain it since you weren't there.
No, I don't
He
want to
literally
know it.
didn't even entertain any argument. He just said motion granted. So,
Yeah, and so you knew that he had done no work prior to the hearing? Is that what you're saying? Because you
What?
have said many times you know what's in people's brains.
I
So
don't-
you're saying he did no work before he went to the bench? Is that correct?
You weren't there. I don't know what he did, but
Exactly.
yeah.
So don't say that he didn't do anything before he ruled, because you don't know, right?
All I said is that he didn't entertain any oral argument. He just said motion granted. That's
Right,
all I
he had your
said.
brief, right? And he had my brief.
Yeah.
The case was so obvious, he didn't want to hear oral argument.
You
had
weren't
screwed up, you had made errors.
you weren't there. You don't know.
I didn't have to be, and yes, I was there.
You were?
Yeah.
Oh my gosh. How are you there? You
What
weren't
does it
there.
matter?
Your co-counsel from downriver was there. You were not there.
What does it matter where he lives?
I'm just saying you were in Florida. You weren't in Madison Heights.
You sure that I was in Florida?
Well, you weren't
Are
in
you watching me too?
You
Or
were-
was I doing a video and telling you?
You weren't in Madison Heights on that day, and I can
Anyway.
pull the transcript and show ya.
You're saying I didn't appear on the record.
I'm saying on the date of this hearing,
Yeah.
you weren't there, and you don't know what the judge
Didn't
did.
see me in court?
What? You weren't there?
How do you know?
Because I was there.
Great.
And we can pull the transcript of the hearing, and I'd love...
Which I did not appear for.
Okay, well then we're on the same page. What are we
Okay.
arguing about? At
But the point
5
I'm
o'clock?
making, and you know this is true, decisions are made all the time on the briefs, especially if it's a slam dunk.
You don't know.
And you agreed that it was demonstrably, he had a good cause, is the analysis that you said.
He had a good cause, but he didn't have a meritorious defense. And the reason why is because at the end of this, when the judgment was set aside, after we went through the litigation process with discovery, with case evaluation, the claim settled. So he didn't have a meritorious
You
defense.
said that you went through mediation, and one of the mediators told you Parker's a jerk or an idiot and he has no case. Why is he doing this? Is that correct? Is that
No,
paraphrased?
one of the lady there said, geez, what did you do to this guy? Is Mr. Ward like his best friend? It seems crazy that he's this invested in this lawsuit. It seems very fishy. And I said, listen, this guy has a beef with me. He has a history. He doesn't like me. And he goes full board against
Okay,
me.
so-
Obviously, because this deposition was supposed to start at 10 and it's now 5:12.
You keep talking in terms, at least 20 times by your estimation, that Mr. Ward took. That same mediator was part of a mediation panel that said the case was really only worth, even though you asked for $13,000.
Okay.
Are you claiming that the panel was wrong and they didn't see it the way you saw it and I had no case?
No, the panel's job is to put an award on the case that they think it'll settle for. They don't make judgments, and they put a value on the case that I probably should have settled for, so they did a good job.
Why do you think it probably should have settled for?
Well, your client accepted that.
Why do you think it should have settled for?
Because you're representing this guy, and usually you go full board, and you don't want your clients to pay anything. So,
And
and some
what is
clients
wrong
have
with
histories with you because you have such a great reputation in our side of the bar.
What is wrong with advocating for your client as the bar demands? What is wrong with that?
It's fine unless you fabricate damages, unless you do workarounds of Supreme Court opinions that you don't like.
Are you
It's
saying
fine.
I fabricated damages?
I'm saying that's why I said in the Rule 11, and you didn't say you didn't. You just
Did
kind
you
of pushed
say
it off.
Right now, you're saying I fabricated damages.
That's what you and your client.
So I fabricated damages. is what you're saying.
My understanding is you told your client to do all this extraneous work, even though you were representing them the whole time, so
And
that
who
you
told you
could
this?
stop, so that you could then, at some point in time, claim these great damages in your affidavit, so you could get over the hump of Article 3 standing, which is what you've been doing in another case called Ryder v. Stillman, very similar pattern. And I just said, look, I'm not going to play that way. I'm going to take a look behind the curtain and show you what this guy's actually doing.
And did the panel listen to you?
The motion hasn't been filed yet. You said it, or hasn't been ruled on yet. You said it was moot, and then literally the next day the court said, no, Mr. Parker, we've reviewed this. You got to answer it.
Now, you've made some defamatory, in my opinion, and the other attorney in here against me, even calling me a liar on the record and a drunk.
Sure.
Sure, okay. Did you say any of those things to the attorneys in the Velocity case you just referred to? It was Ryder versus Stillman?
No, I just told him, look, this guy, he makes videos of his phone calls with his clients. It looks like he made a video on YouTube of him talking to his client, Mr. Ryder, discussing a settlement, discussing very specific details of the case, and then you would tell Mr. Ryder, you're not going to get anything from this lawsuit at all. I'm going to get all the money. That's basically what you said.
That's a video of mine you're claiming?
Yeah, it was on the Parker live cam, and you took it down because, I'm assuming, because of this issue, but I heard it, and I saw you breach the
All right.
attorney-client
And
privilege.
did you tell Stillman this?
I did, actually.
You told him I breached the attorney-client privilege.
I did on your Parker live cam, and I can probably get you the date, too.
Okay.
And you were saying basically to your
Did
client...
he ask you to reach out and tell him this, or you voluntarily went and told him that?
I told him myself.
All right.
He's the competition, but we got other things to do. I know you got a big thing for him too, so.
Michael and I have known each other for years, and he's
Yeah.
in the same neighborhood of me up until a couple of years ago. That's it.
Till you
He stops by, says hello when I'm cutting the grass.
you don't even live there anymore. You live in Florida.
Like I said, a couple of years ago.
Oh,
So
okay.
that's why I don't see him anymore.
Oh, and I'm sure you and him are best buddies. Just like when you
No,
told the clerk at our hearing, you're like, me and Mr. Johnson are best friends, and the clerk's looking at you like, well, why are you suing him then?
Okay. Okay.
Yeah,
So
I think we're done. So just keep
you
going.
want to... I can't go any further.
Good.
We've gone through all that. I'm going to get you out of here as quickly as I can.
Yeah.
But every question I ask you, you end up defaming me.
Oh, I have to tell the truth. So sorry.
Well,
I'm
what's
under
holding
oath.
you back here?
I'm under oath to tell the truth. So that's what I think.
You realize that when you sign a document saying to federal court that you're also under oath?
Yeah, I guess. Okay,
You
well,
guess? You have no idea?
Are you going back to the affirmative defense?
No, it's a question.
Again, I just pled an affirmative defense. It may be true. There may be an arbitration
Almost finished,
agreement.
Philip.
I don't know. But I don't know what the federal court thinks about fabricating damages. I guess we'll find out. Hopefully, at some point.
All right, so cleaning up something here.
Good.
You're unable to provide me a complete and unredacted copy of the Exhibit A that's referenced in all three assignments.
I can get you an Excel spreadsheet with all your clients' information.
That's not what I asked you.
If that's what you want.
The one in 2018. the assignment between Genesis and Real Max Surety Company
Sure.
refers to Exhibit A, I think.
Uh-huh.
Do you have a copy of that?
I don't know. I have an Excel spreadsheet. That's all I have.
The one in October 2021 between a company called Real Max and your client SCS refers to Exhibit A. Do you have a copy of that?
I don't know what Exhibit A is. I might have it, I might not. Again, I
Okay.
didn't draft this document.
But it's an assignment that you're claiming proves your client owns the debt when he sued my client. Do you have a copy of that Exhibit A?
I have an Excel spreadsheet. If that's what Exhibit A is, then yes. I don't know what Exhibit A is, though. I've said that many times.
You don't know what the Exhibit A that it refers to is. Is that correct?
That's right.
Okay. And you've already said that there's something wrong with the account number for the credit report. What did you do to assure that you have Exhibit A that is attached to all three assignments? And it doesn't mean it's the same thing. What did you do? What procedures did you do to make sure you had that Exhibit A before you filed the lawsuit?
I don't remember.
Did you do anything?
I don't remember.
Okay. Is I don't remember one of your affirmative defenses?
You can read them. No.
No, it isn't. Okay. So
I don't remember the specific case. We have, like, a lot of cases.
we do not. So
I do.
what is your having a lot of cases got to do with this?
I don't remember specifics about what I did on this case 2 years ago when I've had, like I said, I file a lot of lawsuits. I have a lot of cases.
When did you become aware that you'd be asked this question through me sending you a deposition notice?
What question?
When did I send you a deposition notice? You've had it for 2 weeks now, right?
Yeah,
But I was going to
I've-
ask you the basis of the assignment. It specifically says that in the notice.
Okay, well,
Did you go and find the Exhibit A after receiving my deposition notice?
No.
No. Okay, so
I got 3 notices from you. You canceled a couple deps.
do you have any evidence that a company called Reliamax exists?
No.
But that didn't, so you didn't check that out either? Didn't
Well,
go to
you
a
said
court?
they went into bankruptcy, so I think it's pretty hard for a company in bankruptcy to then sue your client.
You're right, but at the time that you attached it to your pleadings, none of us knew that they were in bankruptcy, and they weren't. So what did you do when you saw Exhibit A attached or not attached to the assignment? Did you go look for it?
No.
Right. So, would you agree that Exhibit A would prove that the specific debt of my client was assigned between the entities that assigned it? Would you agree to that?
No, because I don't even know what Exhibit A is.
So did you do something to find out if the specific debt of my client was transferred between these different entities in the chain of title? Did you do something like that?
Again, I have an Excel spreadsheet with all your clients' information, so I'm pretty sure it was in that batch.
Okay, back to my question.
Yeah.
You saw the word Exhibit A in the assignments,
Yes, I did.
including the assignment with the Real Max that you obtained and had before you filed the lawsuit. Did you make any efforts to find Exhibit A?
No, we just use what we have.
Okay. So,
It was good enough to settle this case.
that's the whole case right there. So,
What case?
I'm going to move on, and I thank you all for being patient with me. That's just the way I work. Is there any other bill of sale, assignment, or affidavit showing something of Mr. Ward's debt with the account number on the credit report that you provided today
That's
being
really...
ass-
Go on.
being assigned from somebody to someone else?
That's such a compound question. I don't even know what you're saying.
Do you have evidence that the debt that you provided, the account number, was transferred between anyone?
I have bills of sale. Again, your client.
Yes or no?
Yes, I have all the documentation we went over. And I have an Excel spreadsheet with your client's personal information in it. Yes, I do have that.
The account number
Oh my
in the
God.
credit report that you said you pulled, is that in any of the information
I don't know. I'll have to look at it.
showing an assignment of my client's debt?
I'll have to look at the Excel spreadsheet.
Okay, you've had that in your possession since May of 2023, correct? When I say that,
I guess.
I'm not making that exhibit because it has too much personal information unredacted.
Oh,
But
well, that's nice.
Do you want to make an exhibit?
no, but you're the one who files stuff with your client's driver's license out there in
I
public.
don't know what that's got to do with here. So you're saying it's okay for you to do it again?
I didn't put this in the credit report. I didn't put this in any pleading, and you can see from my exhibits, I redacted. Bingo, bango, case over.
So you have Exhibit A that you also
I have an Excel
not redacted?
I have an Excel spreadsheet. I don't know what it is. I don't know what Exhibit A it is. All I know it is has your client's personal information. I'm sure you've done this enough times that you know about this. And again, Livonia Properties, the Hamilton case, everything. There's just, this is done. This whole type of
Okay,
case is done.
So the exhibit...
You're a dinosaur.
Okay. The Excel sheet,
Uh-huh.
you created it or someone else created it?
I didn't create it.
And you got it from?
It was part of the loan documents.
From whom?
Security credit.
Security Credit created a Excel sheet, or was it somebody before
Don't
Security
know.
Credit?
Don't know, don't care.
Then why are you depending on something you don't know how it was created?
I'm depending on something because this case has been resolved. Your client paid. It's over. I don't know why he's
This case
coming
that we're in
back here.
today?
The state court case, the one with the assignments
This
and
is
all the
based
proof.
upon?
I don't know how you can tell a state court you settled it, and now you're going to tell a federal court we had major issues with the assignment.
So you don't know who created the
I-
Excel sheet, is that correct, sir?
That's correct, sir.
And did you ask?
No.
The reason I ask is
Yeah.
you understand, perhaps you understand evidence, and that's got to go through what's called an indicia of reliability. There has to be something credible. You have to know who created the document. For example, you created that affidavit and you said, I've gone over all the records, I know everything that's part of the record. You have a Excel sheet that you appear to want to depend upon. You don't know who created it. You don't know what records it's based upon. Is that correct?
But
But you're saying is or isn't or maybe Exhibit A of all these assignments?
I don't know what it is. I keep saying that. So.
Have you looked at Exhibit A?
Not recently, no.
Then what is the proof that my client's debt was transferred in any of those assignments?
The proof is that no other entity other than Security Credit Services, to my knowledge, has ever tried to collect this student loan debt. Nobody else. The only other two you could get are Genesis Credit Union. By the way, Genesis Credit Union, your client was clearly a member there. He had a lot of money there. Genesis Credit Union didn't say, "Oop, we want that for our student loan." They didn't say that. And then Reliamax. My understanding is everything was liquidated in the bankruptcy, so they're out. So there's only one person left in this game of musical chairs, and it's Security Credit Services, LLC. And that's based on 100 years of Michigan case law, which
Okay.
you're aware of.
Right. And if the debt of my client passes between those entities,
Yeah?
you, sir, are correct in some weird way. Do you, back to my question, it's got nothing to do with who he paid, how he settled, because this was done before when you filed the lawsuit.
Okay.
Did you have evidence that the debt specific to my client passed between at least 3 entities? Do you have something that shows the client, the account number passing between these entities? Yes or no?
I have an Excel spreadsheet with some numbers on it.
And that you said you received from Genesis?
I got it from Security Credit Services. I don't know where they got it. And to talk about evidence when evidence is really for trials and all that, I
Nothing
think
comes in if it's not evidence.
is a little disingenuous. But
I don't know how that is the case, but I will ask the question again, and I want you to focus in so we can leave.
I'm tired.
Well, yeah, you've kept us here with your diatribes about what a bad guy I am.
I never said you were a bad guy.
You've done. That's probably the only thing you haven't said. So
Yeah,
anyway,
go ahead.
I know calling me a liar means I'm a good guy.
Oh,
So-
well, I didn't call you a liar. It's pretty much
Do
obvious.
you want us to read back what?
It's in the Rule 11.
Okay.
Draw your own conclusions. And if you
So-
had an issue with it, you would have screamed every name in the book in your response, and your response was very tepid.
Can we get back to so we can get out of here? This is
Thank-
what you do, and then say, "Why am I still here?"
Yeah, great.
Get the lights.
Oh, get the lights.
She's good at it.
Yeah, you're a piece of-
Anyway, we're going to finish this up.
Good.
If I can get the right question
Yeah,
and get you to understand what I'm asking. So I'm going to rephrase my question.
I know everything. Go ahead.
Genesis passed some kind of debt on to RealMX Surety Company. Do you have evidence of that debt being passed to RealMX? You say you have an Excel spreadsheet. Do you have anything else other than that?
I have the assignment with your client's name on it from Genesis to RealMX, which we've gone over.
And it has the account number?
I don't know. You're gonna make me look for it. Oh, perfect. I'll find it. It's on this page. Okay, Plaintiff's Exhibit 1, page 21. I don't see the account number on there.
So there's no evidence that his debt passed from Genesis to anybody that you
Yeah.
have attached to the lawsuit?
There is a lot of evidence.
Oh,
yes.
there is, if
Yes.
you could.
Okay, if Genesis still owned this debt, I don't think they would allow your client to maintain accounts there, allow your client to have over $9,000 in his account there. I don't think they would do that. I think they say, Mr. Ward, sir, you owe us for this student loan.
Bradley, you
Why
also
are you...
told us that you believe that people are talking to you from the TV. I don't want to get into what you believe.
And you've said
I
the
want
voices...
to
Go
frame
ahead. I'm done.
Evidence. Do you have evidence of Genesis passing with the account number to RealMX Surety Company? Yes or no?
Yes, I have the document you've referenced a million times.
What document is that?
Exhibit 1, page 21. Page
Which
20.
says the account number in it?
No.
No. All right. So
many
you
s-
don't have evidence
Oh.
of the account number. It's an easy thing. If you have it, you have it, and you don't.
Oh,
Do you have evidence from RealMX Surety Company sending anything to anybody with an account number stating Colin Ward's name? Do you have that?
I don't know. I'll have to look at the Excel spreadsheet.
So you've had the case for over 2 years. Have you seen anything that says that?
I'll have to look at the Excel spreadsheet.
Is the account number, let's help you out here, is the account number in the document, I think it's called Bill of Sale and Assignment, between RealMX and SCS? Is there an account number of my client or even his name?
I'll have to look at the Excel spreadsheet.
I'm talking about the document.
No.
No, that's right.
Ooh.
So from what I can tell, there's no evidence that the debt is owned by your company.
Gosh, then it's crazy that your client paid my client and
All
there's
right.
no evidence. It's just crazy.
I'm not going to get into the many reasons why people, you've said what you said, you don't need to keep saying it.
I will keep saying it over and over again
Okay.
because this is ridiculous.
All right. It isn't ridiculous, though, when I'm asking you something you've known for 2 years. You would know if your client owned a debt. And you keep talking about a mythical Excel sheet, which would say the debt is passed to whomever, yet for some reason you can't report to me today that you've read that in the Excel sheet. How many times have you read the Excel sheet? Question?
I don't know. I have no idea. I don't remember.
Did you read it in preparation for your deposition today?
No.
Why not?
Because I don't... Talking about assignments when your clients settle the debt is just ridiculous and a total waste of time.
Tell me one case where a settlement of a debt proves a previous assignment, if you could.
I don't have one off the top of my head, but it's crazy that your client settled this debt and now a year later is suing me on bad assignments. I think that is wacky.
Okay, so is this one of those, I've seen the Excel sheet, but I don't remember it? You've seen a case where it says, because the case settled for whatever reason, that means the debt was assigned. Can you just give me one case, because you keep relying on that? Tell me one case, one court rule,
Okay.
one statute.
I'll give
that
you a
says
case.
Okay, sorry, go ahead.
Give you a case. It's called Security Credit Services LLC versus Colin P. Ward in the 43rd District Court, case number 23 MH 071299GC.
So
That's
you
the
know
case.
when I say, like you keep reporting the Lincoln Properties case.
Livonia Properties.
Livonia, see? You know it.
I do know it very
Yes.
well, and you keep not...
So you know what I mean when I say case. Tell me one Michigan Court of Appeals, Michigan Supreme Court, Federal Sixth Circuit, or even out of the circuit that says payment on a case is proof of an assignment of a debt. Give me one case.
Livonia Properties in Hamilton say that.
Say
Yes, they
that
do.
if you pay the debt, it proves the assignment.
It says your client has no standing to challenge the assignment of the
Okay,
debt.
I'm sure it does.
Yes,
Now
it-
tell me one case that says, because you keep saying
No,
this.
stop.
Your client paid on it, so the assignment is there. Tell us
Let me
one
finish.
case.
Thank you. It's called Livonia Properties, and then there's Hamilton. And basically what these cases stand for is the proposition that if there is no risk of double payment, if a claimant can't say, hey, Company A is suing me on this debt, but I'm already paying Company B on this debt, I don't know what's going on. Who should I be paying? Obviously, there's a risk of double payment there. So then you can challenge the assignment of the debt. However, when you're, in this case, there was nobody else stating that they wanted Mr. Ward to pay on this student loan debt, as far as I could tell. As you've clearly said, it's coming up on the statute of limitations. When there's no risk of double payment, your client, in this case, in the state case, in any case, has no standing to challenge the validity of assignment documents, and that's all we've been doing here today.
All right, so we haven't, but that also says if there's fraud in the transaction, correct?
You have to prove that with specificity, and you've done none of that.
We weren't talking about whether I have or not. We're talking about there are exceptions to that, if that applied. Thank you. You clearly know your case. Now, back to my question. What's a court rule, a case, a statute, anything that says this assignment is transferred, at least in this case, between three entities because later on the defendant settled for whatever reason? How does that make him, whether he has a right to challenge the assignment, how does that make the assignment transfer a loan from one entity to another?
That's such a... I can't understand that question.
How does his payment and the settlement prove an assignment of a debt?
He didn't come to us and say, hey, guys,
Right. He did none of that.
I'm paying somebody else. Or, hey, look, I'm being sued in Bloomfield by another entity that owns
Mr.
this
Johnson,
debt.
listen to my question.
I'm not done answering.
Okay.
So he didn't say that. He didn't say any of that. You did all your assignment stuff. You did it in the state case. You're doing it here today. Just the simple fact is you don't have standing to do any of this because there's no risk of double payment. Your client in, 8 years made one payment of to my client, and that satisfied the debt. And to my knowledge, to this day, nobody else has come forward and said, no, Mr. Ward, that was wrong. You
All
were
right,
supposed
you
to
said your
pay.
piece again.
I'm not finished.
Ugh.
So we're just going to keep going.
Well, you want to get out of here or not?
Well, I'm answering
You
your
keep
question.
repeating the same thing.
Stop.
I agree. That I hear what you're saying. You don't need to say it again.
I'm going to say it.
Now, back to my question.
I'm not done.
Okay, go ahead. You're here
So
still.
you were... Nobody else was coming forward. Nobody.
So you've said 3 times.
And at that point, it's like, okay, we own it. Security Credit owns it. Just pay us and we'll leave you alone. But that's not what happened here. Now your client's suing me saying that this assignment was improper and I should face damages, which is crazy because this has been settled.
All right, so now...
And does your client have a malpractice claim against you because you allowed him to pay this claim?
Wait, so now,
Yeah,
back
go
to my
ahead.
question.
Yeah, go ahead.
Provide me with one of 3 things: a statute, case law, or a court rule that says a settlement payment is proof of an assignment that occurred, in some case, years before the case was even filed.
I don't have one off the top of my head. It's just common sense.
Okay, so here's my question, okay? We
Sure.
think an assignment was made with something between Genesis and Real Max Surety Company. 2018?
If you say so.
You want to look at the documents and go through them again?
I'm so tired of this.
And you're saying Mr. Ward paid in 2024? Yes?
So, could
So
have been in 23. I don't remember.
let's say 23 if you want.
Sure.
What's the proof that the future payment by Mr. Ward proves that an assignment was made in 2018? You're saying, I believe, why would he pay on this, right?
Right. He has a great attorney like you. It's clear that you know your assignments better than anybody. But it's settled. It's done.
So
it's
you
over.
have-
Finito.
Only one reason to sell a case is because you owe the debt. Do
That's-
people settle debts because it's for nuisance value, because they don't want to pay more than the case is worth? Does that happen?
That does happen.
Yes.
But
There's
I don't.
more than one reason why somebody pays.
I don't know why somebody would settle a case when he had a slam dunk statute of
Right.
limitations defense.
And you've told us what you think is normal, right? And it maybe isn't, but you think it's normal, but we're not looking at what you think or feel
I
and
think
some of the stuff in your brain. We're saying, is there either a statute, a rule, or a case law that says 5 years before a settlement or a case is even filed, that means the assignment is going to assign his specific debt that he settles 5 years later? Is there a case law?
I
Is
don't
there
know.
a statute?
I don't know.
So there is one, you think, you just don't know it.
I don't
Is
know.
this on video? Did the guy doing the video about this talk to you specifically?
I don't know. I don't know every case. I'm
All
sorry.
right, so it's possible there was a case that said a payment of 5 years later, settling a case, not even on the debt, but settling the case, is proof that an assignment occurred 5 years ago, or any number of years ago. Yes? That's your evidence? That's your testimony today?
My testimony is if your client had issues with the assignment, he shouldn't have settled the debt and he shouldn't have paid my client any money because he had an affirmative, and he also had affirmative defenses of the statute of limitations. I don't know
so you're
why.
not going to answer that question.
I don't know why he wouldn't pay us anything,
Okay.
and I don't
Fair
know
enough.
why he didn't
Let me
file
just
it.
go through my notes here, and we'll close this out for you.
I didn't finish. I don't know why he didn't file a motion for summary disposition on statute of limitations because it was a slam dunk. You could have got him out of this and paid zero.
Why was it a slam dunk?
Because you're suing me on statute of limitations. It seems like it's a great
you
one.
just said the case with my client where you were suing him, he would have won on the summary motion, and it was a slam dunk. Why is that?
I don't know, because he's suing me on the statute of limitations.
Didn't
So
answer my question.
Yes,
you
I
just
did.
testified on the record that the case you had against my client could have been easily beat
yeah,
by a summary motion. Is that correct?
I was being sarcastic. I don't know if that's coming through on the video, but I was being very sarcastic when I said that.
You said it was a slam dunk.
It should be a slam dunk for you. I don't know why you didn't file the motion.
Okay, thank you. I don't need to go any further. I thank you for your time. Do you have any more questions or anything you want to rehab on yourself?
No.
No? All right, then that's usually what you give the other attorney to do. So thank you, you're done, unless you want to keep going.
Nonsense.
Transcript of video order on the record, please.
Yes.
Wow. It's going to be a
I
lot.
want the video first. Okay.
Yeah. 7 hours of YouTube. Good luck.
Would you like your transcription? Electronic copy?
I'm getting the video first, and then I will later order the transcript.
Okay, so no order now for the transcript?
Not now,
Okay, thank you.
but give me cards or whatever. Usually I got a card. You got a card?
Yeah, let's go off the record at
Got it, I got it.
5:43 p.m.